Up next, we have someone that is an expert in the field. She's worked in family law throughout her career. I would like to bring up to the podium Morgan O'Hare Gering, who is a family law attorney out of Wichita, and she would like to speak about the bill and the benefits of it. And so she is from O'Hara Law Office. So please welcome Morgan and Charlie O'Hare. So thank you very much.
I'm Morgan O'Hara Gering, but I'm going to let my father, Charlie O'Hara, is going to speak first, and then I'll speak second.
And I'll be quite brief here, but I've been doing this for 42 years. And basically, during that 42 years, the legislature and the judges and the attorneys always want the status quo to remain in effect. Always. They never want to change. So when I read this bill, the first thing I looked at, it says presumption of equal. What in the world would be wrong with that? Everywhere we go in the United States. I mean, are we supposed to walk into a courtroom and the judge go, well, I'm not presuming the party's equal? Is that what they're asking? It doesn't make any sense. And what we look at is we have to have a rational basis for what we do. There is no rational basis that the judge can't look at the father and the mother or the husband and the wife or whatever and just equally look at them and decide what to do with the children. There should be no preference to anybody. And when I read the opposition, which Morgan and I read about and talked about all the way up here, and maybe some of you don't remember, it reminds me of the movie Big with Tom Hanks. Tom Hanks looks at something and says, I don't get it. And to tell you the truth, I don't get any opposition to this bill. It makes complete sense. There's no reason to not have it. I'll tell you a little bit of history. I do a lot of criminal law. In criminal law before 1993, the judges could do whatever they wanted with every defendant. And that's how the judges wanted it, and that's how a lot of the attorneys wanted it. Well, it was just a mess. In Sedgwick County, one judge would send our client to prison, the next judge would give him probation. It was just Russian roulette, basically. So what the legislature did is say, well, we're going to bring in guidelines, and we're going to tell the judge this is what you have to do, but there are exceptions for substantial and compelling reasons. Since 1993, that's how it's been, and it's worked. A presumption, there is nothing wrong with. We have the presumption of innocence. We have sentences that are presumed. There is no reason not to pass this bill. And basically, before Morgan gets up here, I want to quote something from the Supreme Court of the United States. And it was by Oliver Wendell Holmes. And this is what they wrote, quoting Oliver Wendell Holmes. It is revolting to have no better reason for a rule of law than it was laid down at the time of Henry IV. It is still more revolting if the grounds upon which it was laid down have vanished long since and the rule simply persists from blind imitation of the past. That's what's going on with the law that we have, is blind limitation of the past. They won't change the law, and it needs to be changed. And now I'll let you have Morgan tell you the details and the mechanics of at least what happens in our districts where people just get basically worked over by the system. She'll tell you now. Thank you.
My father's always hard to follow after a speech. I'm Morgan O'Hara Gering. I'm from Wichita, Kansas. I practice primarily family law. I deal with a lot of what this bill is about. I deal with it every day. It's my understanding, I think from the previous speaker, Dad's Care too is from Wichita. So I'm going to talk a little bit about really some of my experience down in Wichita, and my guess is that you guys probably have a lot of experience with what I'm going to say. In a divorce case, a lot of times what happens with the way the current law is that people are going to race to the courthouse to see who files first, because the first person that files gets to set an ex parte temporary order. And that's a lot of legal jargon, but what that means is that the person that files first gets to, without the other side present, without their attorney present, tells the judge, this is what I want, and generally that's what you're going to get. And then the person that didn't file first then has to go file file a motion and then basically prove to the judge, this is why the temporary order should be changed. So the person that files first gets an advantage. Now, people that oppose this bill are probably going to say that that's not true, but I deal with this every day, and that is the reality of what happens. Now, it doesn't happen in every case, but I would say a lot of cases, that's really what happens, is it's a race to the courthouse. So what then happens is they talk about those factors. I read through the Judicial Council Committee report. They talk about these factors. The ex parte order entered by a judge doesn't consider all those factors. In Sedgwick County, there's only a few things you have to fill out on an affidavit, and the judge signs it, so you can get primary custody without any of those factors being considered. And then in Sedgwick County, if you are the recipient of the divorce, you didn't file, so you're the respondent, you got to file a motion to change the temporary order. You don't get an evidentiary hearing. You basically go up there, and both sides argue. If you have an attorney, it's a proffer, so they just tell the judge their side, the other side tells the judge their side, and generally the judge says, okay, well, I'm going to send you to some sort of alternative dispute resolution. I'm not going to change anything. So the person that filed first still has the advantage. You set it for trial, and you may not get a trial for a year. And then when you go to trial, the person that filed first says, well, this is what we've been doing for a year, and it's working. And then, so there, right off the bat, the person that files first gets the advantage. If you go into court, and I've told Will this, another option is that both sides get to go appear in front of a judge, get to present evidence right off the bat in a divorce, and nobody gets an advantage by filing first. There's no ex parte temporary order. Everybody gets to present evidence, and the judge considers the factors and makes a decision. But that's not the way the law is set up right now. So if the bill is to be passed and it says the judge, both parties come in, the judge looks at the mom and dad, I don't know, I agree with my father. Why would you have any other presumption than it should be equal if you don't know these people, you never heard anything about them? It should be equal until somebody tells you why it should be different. And there are going to be cases, and I've dealt with those, where it may be that shared parenting is not, adequate for the situation. There's going to be, if there's domestic violence, I believe the bill allows for, if you can present that there's been domestic violence, then you shouldn't have shared parenting in that situation. Or, there's some situations where there may be a stay-at-home mom that's done all of the duties, and the father works. There's different scenarios where shared parenting wouldn't work. This bill allows that, but it presumes off the bat it should be shared unless you tell me otherwise. Again, with this day and age, I don't understand what the problem with that would be. We've got everybody fighting for equal rights on all different levels all over the country. Why should moms and dads not be treated equally? And another thing that I think this bill would do is, I respect the people that were involved in doing the Judicial Council report, but I do have to respectfully disagree with them. I think that it would promote people to settle, actually, and it would cut down on litigation costs, because if you go in and know it's going to be 50-50 unless you can prove these factors of why, then if you have an attorney, a good attorney is going to tell you, listen, I don't think you're going to be able to prove this. You're going to spend a bunch of money doing this, and they'll probably end up with shared. So I think that we can, as attorneys, advise our clients better if there's a standard that we go off of. Right now, they have these factors, and you go in there, and it's basically a free-for-all, and you have no idea what judge is going to go which way. If you have a standard, then the judges are going to have a standard that they need to follow. You won't have one party going to one judge and getting one result, and their friend going to another judge and getting a different result. I have people come to me all the time and say, well, my friend had a similar circumstances and went to this judge and got shared, and then they go over here, similar circumstance, and then they don't get shared. And I don't have an answer for that. Each case is different, but there should be some harmony, some uniformity within the judicial system and the judges on having a similar outcome for similar circumstances. And if we have a standard, we as attorneys can advise our clients on how to settle and what to do, instead of it being a free-for-all when you go argue. So also in the Judicial Council report, I noted that they had some constitutional concerns about divorced parents being treated differently than parents that are in a paternity action. But I don't know if everybody knows this, but in a divorce action, you get an ex parte temporary order like I talked about earlier. In a paternity action, when the parents were never married, but let's say you were together for 5 years, you don't get, when you file that action, you don't get to set a temporary order. Basically, everybody has to go and have a hearing with notice in front of a judge, and then they issue an order. So my rebuttal to that argument of the Judicial Committee is, well, parents that are in a paternity action and divorced parents aren't getting treated the same, because one set's getting a temporary order by getting an advantage of filing first, and in the paternity action, you're not getting that. So it has to go both ways. And really, whether you're divorced or it's a paternity action, parents should be treated the same, and there should be no reason that right off the bat, with no other information before the court, that we shouldn't have look at both parents equally and treat them equally. So again, I'm going to basically repeat kind of what my father said. I really don't see that there's any reason why this bill should not be passed. I think that it would be good. I can't speak for all the counties in Kansas, but in Sedgwick County, it would really be a good thing. It would really help our family law system down there. I'm sure you men from Wichita would agree with me. I think that it would really be helpful, and I don't see any basis why we shouldn't treat both moms and dads equally. Thank you.
Wow. That is refreshing to hear. Can we get another round of applause? I think if you two were ever to run for office, you would have a lot of people out here that would be supporting you. I would personally come walk for either of you. That is great to hear. Wonderful speeches. Also, if anybody is looking for a law firm that's going through this, here is a law firm, O'Hara & O'Hara. They understand. There you go.